somewhere.
Yeah, somewhere. No, she's up north at our cottage.
All right.
So, just trying to get some work done. We're trying to get some different things accomplished. You're not gonna play the theme song,
All right.
just because she's not here, are you?
You know, I forgot it.
You did?
I'll get it back out.
No, that's okay. No big deal. Okay, no sweat. So without her, what on earth can we talk about today?
I don't even have a clue.
Okay, we could talk about how good she is.
I've
what
been talking here for 5 hours.
Well, I'll tell you what. I'm a lawyer. I can talk on any subject for any length
There
of
you
time,
go.
whether I know anything about it or not. First order of business, though, is I don't slice. You said
hooked?
before. No, I was hitting the ball pretty well yesterday.
Really?
Yeah.
Okay.
Yeah,
But you
yeah.
did play yesterday.
Yeah, don't let your listeners know this, but I'm not Catholic, so I didn't
Well,
have to go to church. I didn't have to do anything. I told you, I emailed a buddy of mine. I said, let's have Easter services 1:30 at the Country Club at Jackson. So yeah, the course was deserted when I was out there. It was great. So
How's the course?
oh, beautiful. Yeah, they do a great job out there. It really is a spectacular golf course. The greenskeeper and the pro and
Meticulous.
assistant pro. Actually, the pro, Henry Thompson, who's the pro, and then Ron Berman, what's his title, golf director or something like that. So yeah, these guys are really, really good. Anyway, so Troy Ganton asked me to talk about possession of property. Do you know Troy?
Yes.
Okay. Anyway, I saw him at Starbucks this morning.
Oh, okay.
I said Laura was not going to be here. What would he like me to talk about now that I'm not forced into a subject that my wife wants to talk about? And he said, well, what about possession and squatters and people who occupy property with or without permission? And I thought it wasn't a bad topic to talk about. You know anything about squatters?
No.
I mean, you know what a squatter is.
I know what a squatter is.
Yeah, somebody that moves into a vacant house without permission, without any sort of consent from the owner, no lease, no nothing. Do you know what you can do with a squatter?
No.
Shoot them?
No. No.
I thought that's what you were going to say.
Oh, I was thinking that, but I didn't dare say it.
All right, here's
I'm
the way.
glad the lawyer said that. not
Yeah,
me.
here's the way it works.
You can't shoot them.
You can't shoot him. Let's
No.
start off with that. That was just a joke. That
Right.
was so nobody can quote you or me as saying
That
it was
was-
Greg O'Connor or Bill Schlechte authorized me to shoot that
Strictly a
person.
one-liner.
Yeah, that was a one-liner. All right, here's the deal. Rodney Dangerfield, one-liner. Here's the deal. About a squatter, you do not have to go through the eviction process. The only time you have to go through the eviction process is when you have let someone lawfully into the premises, or if you could take someone who's an adverse possessor. Adverse possession is 15 years, and I've talked about that on this show before. We're not talking about adverse possession, where someone's adversely possessed your property for 15 years, etc. We're talking about somebody that's come into your property, it's vacant, you've given them no permission, they're a trespasser.
Right.
Call the cops, establish that you own the property, there is no lease. If the police will do so, sometimes they'll say, hey, this is a civil dispute, you're going to have to go to court. But in most circumstances, they're trespassers. You can simply have the police come in and boot them out. You can't, what's difficult is you can't exercise self-help to boot somebody out, even though it's a squatter. If you could get them out without a breach of the peace, in other words, you confront them and they voluntarily move, that's fine. But you can't go in there with 4 big burly guys and move them out, because now that's assault.
Even
that's
if
a
the
breach of
police
peace.
won't help
If
you?
the police won't help you, the answer is no.
What-
That's a problem.
Then what do you go to court?
Yeah, you're going to have to go to court to get a court order and then have the court order enforced by
That's
the police.
insane.
If the police, here's the predicament the police find themselves in is if the squatter says, no, I'm here pursuant to a lease, no, they let me into the property, something like that. Now the police won't act because there is this dispute, even though it's bogus, even though it's frivolous, even though it's unfounded. You're still going to end up having to get a formal court order that can then be enforced by the police. But, a squatter who's there, who doesn't have the temerity or the cojones to actually sit there and claim that you let them into possession, they've been confronted. You take the police out there, if you can persuade them to go with you, and confront them and boot them out as a trespasser. That's trespass. It's both civil trespass, it's also criminal trespass, for which they can be prosecuted in criminal proceedings. Yeah. Yeah.
That's,
But squatting is a real issue. I don't think so much in Jackson. I haven't really, I don't know personally of any cases of squatters here in Jackson. I suspect that there have been some, but
Detroit?
I'm sure there are in Detroit, where you have many homes that are either abandoned or foreclosed. If they're abandoned, of course, the owner probably doesn't care until it goes up for tax sale somewhere. Now the tax sale owner comes in, purchaser comes in. They don't know whether the squatter was put in lawfully or not. So most of the tax sale purchasers, or as a result of a tax foreclosure, end up starting a court proceeding, an eviction, to get a court order that then is enforced by the police.
what if a squatter does something illegal? Are you liable at all for that?
Generally not. There are some forfeiture statutes where, and then they usually apply to landlords. I really haven't confronted in a squatter circumstance.
Like
but it's,
kidnapping and,
no, absolutely not.
Okay.
The owner's not liable for that. I was thinking more in terms of drug activity,
Or
drug house, stuff like that.
anything like that?
Yeah, again, with respect to a squatter, that's a trespasser. You call the cops. Cops will come out, because now I have criminal activity. It's not just a squatter occupying the property. I've got criminal activity. Police will act to remove the criminal, arrest the criminal, stop it, and that's the way you get that squatter out of there.
Isn't squatting a criminal activity?
Yep.
Okay.
Yes, it is. And that's criminal trespass. And that actually segues into a slightly different conversation for people who are buying and selling property, or even landlords. I mean, I just was involved in a case in northern Michigan in which the owner of the property let a prospective tenant into the property. I think I talked about this about a month ago. This is the one where before any lease was signed, before the terms of the lease were agreed upon, he lets them in there to do certain improvements. They come in, they not only make those improvements, they make some improvements without a permit, they move hazardous materials onto the property, and my client's tearing his hair out because now he's got, and I have to tell him, you got to go through the eviction process. You let this prospective tenant lawfully into the premises, now you got to go through the entire court process to get them out. They're not squatting, they've been let lawfully into the premises. Same thing is true.
Now, any landlord should probably be aware of that, right?
They should be, except this particular client is a sophisticated commercial and residential landlord. Why?
And he didn't know that?
Why? Maybe in northern Michigan they trust people more than they do down here. Okay? Look, I've been a lawyer for 44 years.
Yeah.
I trust people. By the way, how
No,
do I
you
say
don't.
this?
No, you don't.
Let's just say that trust is much better when it's put in writing, signed by everybody.
Exactly.
How's that?
Oh, yeah.
Yeah. I mean, actually, when I started in practice in 1972, people actually did things on a handshake basis. But that didn't last long. You get into the 1980s, the first recession there, in the early and mid 80s, and all of a sudden people were reneging on deals, not because they had the intention of reneging at the outset, but because circumstances forced them to.
Right.
So, no, everything you do these days you put in writing. People get angry at lawyers because they think a lawyer puts too much in writing. I can give you a good example. I've got somebody right now that wants to buy a commercial building. We prepare a standard commercial agreement, nothing out of the ordinary, and the seller and the seller's broker, nobody local, this is somebody out of the Detroit area, they come back with a residential agreement, a 2-page residential agreement that's wholly inadequate. Whether that's ignorance, whether it's deliberate ignorance, whether it's actual ignorance, or whether it's simply an attempt to eliminate the basic protections that a purchaser would get in a purchase agreement. I don't know yet. I'll find out. This just happened at the end of last week. But the segue I wanted to make was, if you are a seller of property, your residence, okay, and you're now selling that property, you've already moved into another one, your property's vacant. The deal hasn't closed yet. The purchaser wants to get in before the closing in order to do painting, to rip up carpet, whatever it may be. One of the worst things that a seller of real estate can possibly do is let that purchaser in before the deal closes. So many times the purchaser gets in and two things happen. Two possible things happen. One is the purchaser gets in there, finds things that the purchaser doesn't like, and so now doesn't close as a result of finding things out about the property that weren't disclosed, or just are discovered by the purchaser before the closing. The other is that the purchaser comes in, starts ripping stuff out, starts doing things to the property that the seller doesn't want, and then for one reason or another, typically the financing falls through. Or again, the purchaser just doesn't like the property but stays in there. Now the seller is stuck with a property where the purchaser's in possession, done damage to the property in terms of ripping things out or made changes to the property, and now the seller, there's no closing, and they have to go through the eviction process in order to get the property back. And many of these agreements that you see, the only remedy of the seller is, if it doesn't close, is the seller gets to keep their earnest money deposit, as opposed to being able to go after the purchaser for damages, etc.
Really?
Yeah. I mean, if the deal doesn't close, if they let them into possession, I still say I'm going to be able to go after them, but it's going to be real difficult to do.
Again, probably a scenario 30 years ago, those happened quite a bit.
All the time.
Can't imagine that.
Still happens today.
Does it really?
Yeah. The real estate agents will talk to the sellers. Seller says, "Hey, look, I like these purchasers," or they're I don't want to call them
Seems like
desperate.
the
but
agent
semi-desperate.
would never let that happen,
It happens all the time.
does it?
Yeah, because the closing is delayed. Closing's not going to happen for 30, 45, 60
Right.
days, whatever it may be. Purchaser says, "Hey, I'd really like to get in. I'd like to start doing stuff to the property so that it's ready when I close." Seller's being nice, lets them into possession, says, "What can the harm be?" Lo and behold, now they find out.
Don't you sign something? Or?
Yeah, even though it's signed. Even though the...
Even if you sign something?
Yeah, there is something that's signed, typically. Not always, but typically signed, letting them into possession. Might say that they're liable for damages, etc. But the problem is that you have to go through, and sellers don't understand this. If the purchaser doesn't close, the seller can't simply take the property back. The seller's got to go through the eviction process. And what that's going to be now is, because there was no rent agreement before the closing, right? They're coming in to make improvements, whatever it may be. Even if there is a rent provision, if there's a rent provision, they don't pay the rent, you can do a 7-day notice. If there's no rent payment, you're going to have to do a 30-day notice to terminate. So now I got 30 days before I can even file my lawsuit. I file my lawsuit, I get them served, I now show up on the following Tuesday morning, I get a judgment, I still got 10 days after that. That's if I get a judgment. So getting them out of there is going to take me anywhere from a month to 2 to 3 months to boot them out.
And the courts are busy.
No, the district court here is really good.
They'll get you out?
Yeah. No, I can get before any one of the district court judges very quickly on a landlord-tenant case, and they're all very good in terms of dealing with these things. So, no, I don't have any problems with the district court. We actually are pretty blessed, might be the wrong word here, but we have a very good district court for the most part, and a very good circuit court. I do things all over the state, so I get to see judges in many different circuits. I do stuff in federal court, and I see federal court judges. And I'd say the bench here is pretty good. And so, as a landlord, representing landlords, we can get before the court and get a proceeding going.
But still, time is money.
Time is money, and again, there may be damage that's done to the property while there's prospective purchasers in there. And this is apart from landlord-tenant. I mean, that's a whole different subject in terms of possession and getting possession back, illegal activity on the part of a tenant, that sort of thing. Everything you want to know about possession, but we're afraid to ask.
That's good to know.
Yeah. So what else you want to talk about?
If you're an owner, operator.
If you're an owner, yeah, if you're selling your property, or if you're a landlord, getting possession back is sometimes problematic. I've got one right now where this is a factory owner over in the Detroit area, and we had a tenant who's been in there 10 years. Lease expired on September 30, and they didn't move. Okay? So we send out a notice on before, actually, at least ended October 31, excuse me, not September 30. We send our notice on September 30, a 30-day notice. They don't get out on October 31. We have to go through the process and trying to move all of these stamping machines. It wasn't going to happen overnight. So the eviction process there took us, we finally got them out on January 11. So what's that? November, December, and then January 11. And now my client, all of the stamping equipment, all of the industrial stuff was moved out. Now, of course, we're dealing with what has been done to the property by the tenant during that 10 years because they were using tons of hydraulic and cleaning fluids on the premises. So now we actually had an environmental company come in. They're in the process of assessing exactly what kind of environmental issues may exist and what the cost of repairing them may be. Plus, we've got a huge amount of rent that's due over the 2.5 months that they stayed in there beyond the original lease term. It ain't easy sometimes.
Biggest faux pas
By,
a landlord makes.
oh man, I don't know. Failing to screen a tenant adequately. The landlords, sometimes so desperate for a tenant, won't do the due diligence to check the credit worthiness, the reliability of the previous, of that tenant applicant. That's probably the most difficult thing that a landlord has to go through. And most landlords that aren't professional landlords or professional management companies don't have the resources to be able to check a tenant. I mean, we have a bunch of rental properties, and we have a very thorough credit check that we do. The other mistake that landlords make who do due diligence is they don't do it on a, what's the term here, Jackie, on a consistent basis. In other words, you have to be careful as a landlord. You want to make certain that you have written objective criteria to determine whether or not a tenant qualifies for your property. And you have to set that out so that you don't make special allowances for certain applicants, because if you do, you may end up, whether intentionally or unintentionally, discriminating against persons who are protected under our fair housing laws. And it doesn't matter if you're a landlord and you don't intend to discriminate against any of the protected classifications: race, national origin, religion, familial status, marital status, disability.
How about criminal history?
Now, criminal history you're entitled to ask about, and you can discriminate against anyone with a criminal history. That's one of the issues for particularly felons who apply for rent. Is most sophisticated landlords will ask, do you have a criminal record? And we can find that out easily. The problem is we do have felons who made one really bad mistake, or people who made one bad mistake and they want to rehabilitate themselves. And so how do you go about determining whether or not someone has a sincere desire to rehab? And I gave you two specific examples. One is an applicant for one of our units a week and a half ago, and a person that handles the applications contacted me and said this person has a felony on his record. So I said, here are the questions that we want to ask. I want to find out the details of what it is. I want to talk to the prior landlord. I want to know, does this person have employment? All of these sorts of questions.
Sure.
We finally made the decision that this person, even though he had a record, based upon the additional information we had and the references that we checked, that we would in fact rent it. But we could easily have made a decision not to. I have a client last week, got a call from the client. They had an application from a woman who had a felony on her record. I gave them some information on where to check. I did some checking, determined that in fact what this person was telling my client was not the truth about what the felony was, the circumstances, all that sort of stuff. Based upon the additional investigation that my client made, they declined to rent to this particular applicant. So that's one of the mistakes that landlords make, is in terms of screening. You can't be too careful in terms of screening. The other mistake I think some landlords make is they automatically reject what are called Section 8 applicants. Our own view is Section 8 applicants are actually make some of the best tenants, because there you have to worry much less about getting paid rent, because you're being paid by the Section 8 program, by the government, and the check comes directly to the landlord. Sometimes the rent that you may get on that particular unit is slightly less than what you would get if it were market rate, but I will tell you, as a landlord here in Jackson, Jackie, you agree with this? Section 8
I don't know.
works pretty
enough
well.
about it.
Okay, so.
Call Thinking Real Estate.
Yeah, call my wife Laura. She's an absolute wonderful woman, most motivated, dynamic person I know. She's absolutely spectacular. She is, Greg. She's absolutely spectacular. Phone number 517-780-3800. It's thinkingrealestate.com, and She's been in business since 1984. She's the most experienced, most expert, most knowledgeable, best realtor. Matter of fact, next week we'll talk about selecting a realtor, other than Laura, if you don't pick her. Thanks a lot.